Clarke versus Town of Newburgh.
Thank you, Your Honor. Misha Tsaitlin for the Town of Newburgh. It's a pleasure to be back before you all again, although some of you are in different seats than the last time I was here last month.
Just keeping you on your toes, that's all.
I'd like to reserve 3 minutes for rebuttal if I can.
3?
Yes.
Yes.
The NYVRA's vote dilution provisions do not outlaw discrimination, nor do they even outlaw vote dilution, as that term is used under Section 2 of the federal VRA.
Counsel, why shouldn't we first be focusing on the issue of capacity? I know in your brief you talked a lot about the constitutionality without first addressing capacity, but isn't that a threshold issue that we need to be addressing in the first instance?
Well, what we have argued here in this case is that every possible step that we, Town of Newburgh, could take to comply with the NYVRA's vote dilution provisions will violate the U.S. Constitution.
Well, let me ask you, didn't you make an admission at the Second Department that the way it's being applied in this particular case would be consistent with Gingell's?
No, not at all. Quite the opposite. What we said is that...
Why wouldn't it be? Why wouldn't this particular case comply with the 3 provisions of Gingell's?
Well, that issue is entirely waived. They never raised in the Supreme Court any notion that they're bringing a Gingell's case. It would be a completely different case. In order to bring a Gingell's case, you would have to have experts that opine on the 3 preconditions. Their expert didn't even attempt to opine on them. They'd have to have an expert that does all of the different things.
But counsel, isn't the first issue that has to be decided under the analysis of capacity whether there's any application of the statute that would be constitutional? So if there's any application that could be constitutional, there would not be standing. So isn't one of the applications that would be constitutional if it could be applied in such a way to be consistent with Gingell's?
It would be impossible to apply this statute in a way consistent with Gingell's without striking down multiple aspects of the statute, because the statute itself takes out aspects of Gingell's. So in order to bring a Gingell's case, you'd have to strike down the aspect of the statute that gets rid of the first step of Gingell's. You'd have to strike down the aspect, if I may.
But let's go back to the capacity issue, because there's one thing if you're doing a facial attack on the constitutionality. It's another issue if you have capacity. And to have capacity, you have to establish that there's no possible way to apply this case in a constitutional manner.
This particular statute, Your Honor,
Right.
and this statute on its text takes out aspects of Gingell's. So it's impossible to apply this statute as written under Gingell's. You could apply, so if the court strikes down, I would count 5 aspects of the statute, then that modified statute, which would essentially be Section 2, would then be like Gingell's, but that's not the statute.
But if there are portions of the statute that could be applied in a way that were consistent with Gingell's, wouldn't that mean that you lack capacity? If there's a way to apply portions of the statute in a way that would clearly be consistent with Gingell's and be consistent with Allen, wouldn't that take away your capacity?
That would be a different statute, Your Honor. This statute that we are facially challenging has multiple provisions that are inconsistent with Gingell's. Those provisions are facially unconstitutional.
But how do you know they're going to be applied in this particular case?
No, but that's the case. If you look at their complaint, they're bringing claims under this statute. They have one claim that says there's racially polarized voting. That's their first count. That's not a Gingell's claim. You can't just get a Gingell's win through racially polarized voting. Their second claim says we win because of the all things considered inquiry. That's their second claim. That's not a Gingell's claim. They don't have a Gingell's claim in their case.
What about this case is inconsistent with Gingell's claim? You have, even if you separate the 2 groups, you have a Latino community that's 25% and you have 5 town board members. Why doesn't that fit into the Gingell's test?
There is...
And there's a claim that there's racially polarized voting.
Your Honor, this is a motion to dismiss. This is a motion for summary judgment. They did not attempt to bring a Gingell's claim. If you look at their complaint and their evidence, you'll see no attempt to bring a Gingell's. If they brought a Gingell's claim, we could have removed it to federal court. They had brought a specific
Well,
claim.
they're not bringing a claim under the Federal Voting Rights Act. They're bringing a claim under the New York Voting Rights Act. But if it could be applied in such a way that's consistent with the Gingell's test, then how can it be unconstitutional?
It cannot be applied consistent with the Gingell's test unless you first strike down multiple aspects of it. Let me just give you an example. There's a provision in the NYVRA, can I just?
Go ahead.
There's a provision in the NYVRA that says that I am not allowed to defend against their statistical evidence by saying their attempt to show racially polarized voting can really be explained by politics. In a federal case, I could make that argument. Under the NYVRA, I'm prohibited from making that argument. So how is this a Gingell's claim when there's categories of evidence that I'm not even, an argumentation, that I'm not even allowed to put before the court?
Let's go back, though, to the test. What is the test for capacity? You have to show the dilemma exception. And the dilemma exception is if there's any way that this statute can be constitutionally applied, then you don't have standing. So that's not the way you're arguing it. You're arguing a much broader attack on the statute, that there's some possible way it could be unconstitutional, but isn't the test really is there some possible way it can be constitutional?
Yeah, and our only argument is that there is no possible way. And the way that the constitutional analysis works under the U.S. Supreme Court case law is a two-step inquiry. Step one, does strict scrutiny apply? I can talk to you all about that, why it does. Step two, if I've shown that strict scrutiny applies, which I think it clearly does, then the burden shifts to them. So if the burden shifts to them to show that strict scrutiny has been satisfied.
But, counsel, you're talking in terms of a facial attack on the constitutionality, but that's not what I'm asking about. I'm asking you about the capacity issue, which is a much more limited analysis, arguably. Do you not agree that there's some distinction between the way you address the constitutionality when discussing the dilemma exception as opposed to when you're discussing the case in terms of a facial constitutional attack?
Not in the way we have framed our theory. If we had brought an as-applied challenge, sure. But I'm just going to read this court's decision in Jeter, which both my friends on the other side quote. It says, if the exception applies, if you're, quote, obliged to comply with the statute, that will, by the very nature of compliance, violate the Constitution. That is our entire merits argument. So because we have made our entire merits argument.
I think the problem is that we don't yet know what will be required by compliance, right, in the way of compliance.
Okay, so this is an important point that I really want to emphasize.
Mm-hmm.
Our understanding of the word compliance is comply with regard to the finding of liability. Whether there'll be some remedy later, that could be a different challenge. Our theory is that any step that we could take to comply, because the way the NYVRA works is that if
I'm sorry, you've lost me a little bit.
So let me
comply with the finding of liability?
Yes.
The finding of liability doesn't actually require you to do anything. I don't know how you could comply with a finding of liability.
So the way that the NYVRA works is that if we get an NYVRA notification letter, which they sent us, then we have the option to voluntarily change our voting system in order to come into compliance with the NYVRA. That's the way it works. That's the primary way the NYVRA expects us to comply.
Allows you to.
With the statute. And our submission is that any step that we could take to comply with the NYVRA notification letter.
Your position is you don't have to take any step.
Because
I thought your position is you don't have to take any step because you've not violated their rights. That's the threshold.
We do have an argument that we did not violate the NYVRA. That's true. But we are saying...
That has to be your threshold argument.
No, but we have two threshold arguments. Okay. But the one that I'm presenting to the court is that the way the judicial review of constitutional works is if you've got the state statute, the NYVRA, and you lay down the U.S. Constitution next to it, right, you can't give any effect to the NYVRA because it violates the U.S. Constitution. Our position is that every application of the NYVRA violates the U.S. Constitution.
The New York VRA allows you to win under the statute. You could, right?
Yes,
in theory.
We do have defenses, that's true.
So if this is Judge Rivera's question, I think, which is if that possibility is there, then how do you fit under the fourth exception?
It would be, I think, quite a remarkable expansion or maybe negation of the fourth exception if the fact that a party might have a merits defense that isn't the constitutional offense means that the court that can't even raise the constitutional defense. I mean,
well, that's because, I don't think you dispute the general proposition that political subdivisions of New York State cannot bring an action against the state or challenge the state statute? As a general matter.
As a general matter, we could not file lawsuits challenging the state statute. That's
Or,
correct.
well, right, or even in defense.
No, I very strongly disagree with that,
All
Your
right, so
Honor.
let's,
Because,
that doesn't fit under the fourth exemption particularly, right?
well, and this issue has not been
Right,
adjudicated.
you're asking for a new fifth one, I think.
No, it's my respectful submission is that the fourth exception, as I've articulated, is required by the Supremacy Clause of the U.S. Constitution. That clause, with regard to federal constitutional claims, that clause says that the U.S. Constitution is the supreme law of the land, and it binds every judge, which includes state court judges. So if there is a case, which they have brought against us, and they are laying the NYVRA down in front of the judge and saying, hold the town of Newburgh liable, the small town, hold them liable for violating the NYVRA. And we lay down the U.S. Constitution in front of the Supreme Court, that the Supreme Court is not allowed by the Supremacy Clause not to address the U.S. Constitution.
So can New York State abolish the town of Newburgh?
It could, yes,
And the Supremacy Clause has nothing to say about that.
that's true. But for example, the state of New York legislature could not enact the following statute: the town of Newburgh or any other town can only let in people of certain races into their schools.
Can it divide the town of Newburgh into 5 towns?
It could, but it could not say that those towns have to racially discriminate.
No, but it could divide the town into 5 towns based on geography that might have the same effect as whatever you might be compelled to do here.
Your Honor, I understand what you're getting at. Even though it could do all of those things, this is what it cannot do.
But then I don't understand why the Supremacy Clause matters here.
Well, let me give you a very extreme hypothetical, and I think maybe my friends will disagree, but let's say that tomorrow, the state of New York or any other state, you can take a hypothetical state, says that every town in our state has to not let in people of a certain race into their schools. That's provision. Just let me. No Asians in our schools. And then that's Section 1 of the statute. Section 2 of the statute says no town is allowed to raise in court an argument that this makes us violate the U.S. Constitution. I think it would be an easy case that violates the Supremacy Clause.
But the question here is, what constitutional violation is the Voting Rights Act of New York requiring you to violate?
Absolutely, Your Honor, and that's why I think ultimately it boils down to the merits. I was going to start with the merits. Judge Kern took me on capacity. But if Your Honors agree with my hypothetical, that kind of extreme statute that says that the towns have to clearly act
So
unconstitutionally.
let's look at this statute
Yes, so I would love
and
to
what
discuss the
it
merits.
does or does not do.
Yes.
Because I think there's some disagreement about
Yeah.
it requiring you to violate
Yeah.
the Constitution.
So every application of the NYVRA's vote dilution provisions operates in this way. That a town that happens to have racially polarized voting, which is nothing but the common condition, as the U.S. Supreme Court said, of a discernible, non-random relationship between race and voting. If a town happens to have that, then they have to look at all of the races in their town, and they have to say, are any of the citizens lumped together by those races?
So are you saying they can't even look at race to see if there is something going on with respect to the dilution of the rights of the people that they claim may be affected? They
yeah,
can't even consider that?
No, they can look
No,
at
I asked you a question.
No, yes, but they can look at it. What they can't do is the next thing I was about to say, is they can't, after looking at it, say, well, white voters are not winning enough elections. Black voters are not winning enough elections.
So did they do that here?
What'd you say?
Did they do what you're saying here?
That's what they claim the NYRA forced us to do. And that's what every single...
Have you been ordered to do any of those things?
No, that's because we have brought a facial challenge to the statute, which we have a constitutional right to do, and we are saying that any application of the statute, it's just like my...
The statute provides options, though, correct?
And my argument is that every option we could possibly take would violate...
And that's because those options all tend towards mitigating racially polarized voting, and that's something that just naturally occurs?
It's because all of those options involve the giving out of an important benefit based only on race, which is greater electoral success.
How's adding poll locations or voter education, how does that implicate?
Well, so if one takes, if a town takes an action, let's say X action, and it puts in the legislative findings, we are taking this action only for the exclusive reason of so that white voters will win more elections. That is under the Arlington Heights framework, racial discrimination.
So anything that tends to attempt to remedy this particular type of violation that's laid out in this Voting Rights Act is ipso facto some sort of racially discriminatory effort.
It triggers strict scrutiny. It is racial classification. Whether it's constitutional or not turns on whether you can
What if
satisfy
it's
it.
merely eliminating an advantage that a racial group has?
The specific provisions that are at issue here say that you have to make a change in order to make it so that whatever racial group will win more.
No, it's
no.
talking about dilution. And
That's just-
excuse me,
Yeah.
dilution is referring to the fact that there is a group whose votes are being diluted, which of course means other groups' votes are being advantaged. That's the point of a vote dilution claim.
And the vote dilution is a term brought from
no
the...
court has yet found that there's been vote dilution.
Vote dilution is a term of art from Gingles. What is being
I know
outlawed
Jingles,
here
thank
is not vote dilution at all. It is a statutorily defined term, which is racially polarized voting. Racially polarized voting is not discrimination in any sense, and it's not even vote dilution in any sense. It's just a statutory
And
definition.
no court has interpreted the statute that way. So,
I mean, the statute says what it says. It says vote dilution is established by showing racially polarized voting, and then it defines racially polarized voting. It's not a complicated statute. And so
Well, there's more to it than that, right? It's not just racially polarized voting, it's also, and that group has not had electoral success.
that's not in the statute, Your Honor.
No?
That's not at all in the statute. What we have agreed as a non-statutory element is that the plaintiffs also have to show that there is some other regime under which they would win more. There's nothing in the statute that says that they haven't had.
or
lots
that
of-
another group's advantage would
well,
be
that-
eliminated so that everybody's on an equal playing field.
That's also not in the statute, Your Honor, and that's not that would be just coming up with.
So
elements.
if that were, that it's, if it were so, that the law was just such that no one has an advantage, everybody just has the equal opportunity to participate, then that's not a constitutional violation.
Yeah, but that wouldn't be the statute. Nothing in the statute.
No, but if that were the case, then it wouldn't be a problem, right?
I mean, that's a very kind of high-level principle. If the statute didn't do what it does, then there might be other issues. But the statute itself requires the giving out of a race-based entitlement, which is that you have more electoral success as a racial group. Now, it's a broadly
More
available...
success or more ability to participate without being diluted?
More success, the unwritten...
It guarantees that one have an outcome that they elect a person?
The unwritten element that the plaintiffs and I have agreed upon, in order to make the statute not absurd, is that there has to be a showing that under a different regime, the minority group would do better, which means...
Well, the statute actually does say that they have to show that the ability of that group to obtain electoral representatives is impaired, no?
That's a high-level definition of the statute, but if you actually drill
It's in
down...
the statutory language, no?
No, but if you drill down to the
Is it
operative...
in the statutory language?
It's a
not-
yes or no.
Not in the operative provision here.
Is it in the statutory language?
There's a definition...
I don't know what provisions are operative and what you think are not. Did the legislature write those words into the statute?
That is in a portion of the statute that is not the one that they've alleged that we violated here. What they violated, they have two counts. One is that there's racially polarized voting. That's their count one. Racially polarized voting has nothing to do with what you just said, Your Honor. The other is the all things considered inquiry, which you can based on one factor or not even listed. So whatever that provision, that's not one of the two counts they have brought here. They brought the racially polarized voting count, which has nothing to do with what you just
And
said.
you're not arguing that they have to satisfy that piece of the statute?
What I'm arguing
No,
is that
I'm asking, are you arguing that they have to satisfy the piece of the statute or no?
I don't think anyone has argued that they have to satisfy that piece of the statute, that piece of statute, because it's not an element of the claim. The only statutory elements, the ones that are in the statutes, are either racially polarized voting or the all things considered inquiry.
So this is in the statute for no reason.
It's a general statement of purpose, but then when you actually operationalize it,
Is it identified in the front as a statement of purpose, or is it part of the operative part of the statute?
it's not the operative provision with regard to at-large districts, no.
And it's not something you think you can raise as a defense or make them prove,
No,
even though it's in the statute?
No, the only things that we, well, look,
Just that
obviously
you've
this court-
chosen not to do that to make your claim better?
No, Your Honor, the statute says, this says, vote dilution is illegal. Vote dilution for at-large districts is defined of one of two ways. Either racially polarized voting or all things considered inquiry. The statute is quite simple in that way. We have then agreed with my friends on the other side that there should be an additional element, essentially invented by the courts, that says that at least they have to prove that there is another voting system under which the relevant minority group would do better. We agreed to that element because otherwise the statute would be absurd. What's the point of what is the statute even trying to?
Your point is you got to have a remedy.
Yeah, yes, and so, no, you've got to have an undiluted practice on which you're measuring dilution
That's
against.
called a
And-
remedy.
Yes, well, that's not the way the U.S. Supreme Court has talked about it. They've talked about a benchmark to establish liability, but fair enough, Your Honor, but the point is that that unwritten element still doesn't cure the fundamental constitutional problem in the statute, which is that it is a statutory classification scheme, a race-based entitlement scheme, and a race-based entitlement scheme can only survive under current U.S. Supreme
Why
Court.
isn't that also true in Allen versus Mulligan, which the Supreme Court recently upheld that type of provision and held it was constitutional? Why is this different? That was based on a racial classification also, and the Supreme Court held it was constitutional.
Allen versus Milligan did not consider an equal protection claim at all. It was a
I
decision.
know, but it broadly held that those kind of claims have been going forth for 4 decades throughout the country. They've been upheld consistently throughout the country, including in Allen and Mulligan, and that there was nothing unconstitutional about them.
That's not the way I read it. Allen, and if that was what Allen meant, there's no way the U.S. Supreme Court just a couple of months ago would have ordered re-argument in the Louisiana case, which is being argued tomorrow.
We don't know why they granted certain
Your Honors can look at the briefs in that case. I think everyone recognizes why they did it, which is that they are trying to decide whether strict scrutiny, which clearly applies to Section 2, remains satisfied given the conditions. You look at all the briefs in that case, that's what the argument tomorrow is going to be about. So if Allen meant what Your Honor said, that wouldn't have been a serious question, but U.S. Supreme Court, in a very unusual step, said we're going to have re-argument on this very issue. Now, look, this court is going to decide what it's going to decide in this case, but ultimately, if even Section 2 of the VRA is with a venerable Section 2 that has all 3 Gingell's preconditions and 2 steps, is now being questioned by the U.S. Supreme Court as to whether it's constitutional. I mean, imagine what the U.S. Supreme Court would think of this statute, which guts and eliminates 2 of the 3 Gingell's preconditions, guts the 3rd one. Then it requires influence districts, which the U.S. Supreme Court said is not permitted under Gingell's for constitutional avoidance reasons.
Counsel, it seems to me as if you are indicating that the Gingell's factors are constitutionally required. But it seems to me that it's just a judicial interpretation of Section 2 of the VRA. This is just one way to look at it, that it's not constitutionally required. Can you address that?
Yeah, if you look at, Your Honor, if you look at the Supreme Court's decisions where they've been asked to expand or draw the boundaries on Gingell's broader, which is Bartlett, Lulac, what the U.S. Supreme Court has always said is we're not going to go further. And they've always said one of the reasons is for constitutional avoidance purposes, is because we go further, then we're going to be running into the Equal Protection Clause.
So is it an interpretation or a constitutional requirement?
It's an interpretation in light of constitutional avoidance principles. And if the U.S. Supreme Court is so nervous about expanding Gingell's to include influence districts and things of that sort, imagine what the U.S. Supreme Court would think of a statute that eliminates the first and third preconditions, essentially eliminates the mandatory second step, has these evidentiary requirements where you're not even allowed to argue that what's going on here is politics, but not race. I mean, look, we got to live in the real world, Your Honors. The U.S. This statute is, you couldn't design a statute more likely to goad the U.S. Supreme Court into striking down state-level VRAs, just systematically dismantling step by step all of the Gingell's framework. And it might be that the Louisiana case will just end this whole vote dilution enterprise, and the Supreme Court will say we're done. But the U.S. Supreme Court might chart a middle ground. I would respectfully submit that for those who want to see state-level VRAs step into that breach, this essentially limitless regime is the worst-case scenario for that.
Thank you.
Thank you, Your Honors.
Nick Stephanopoulos for the plaintiffs. May it please the court. I'd like to start with the town's argument as to why it's exempt from the no classification rule that usually applies to political subdivisions. So my friend's argument is that any action Newburgh might take to comply with the NYVRA would be race conscious and therefore necessarily unconstitutional. And it's important to realize that that exact theory has been rejected over and over again by the U.S. Supreme Court, including 2 years ago, most recently, in Allen v. Milligan. So in Milligan, Alabama made the very same argument the town is pressing now, and the court responded that for 4 decades, it has authorized race-conscious redistricting to remedy unlawful district maps. And the court's response in Milligan makes perfect sense because most remedies for voting rights violations neither use racial classifications nor have any kind of invidious purpose. The typical voting rights remedies are things like new district boundaries or alternative electoral systems. These are facially race-neutral electoral policies. And they also have the objective of complying with anti-discrimination law and curing vote dilution. And these are not invidious purposes. And
Can you address his description of vote dilution and your claim?
I'm not exactly sure what the town's understanding of dilution is. The NYVRA has the same conception of dilution, as do 7 other state voting rights acts, and as does the U.S. Supreme Court, as illustrated by the court's decision in Jingle. So the essence of vote dilution is that some electoral practice interacts with social and historical conditions to cause a persistent underrepresentation for some racial or ethnic group. That's exactly what the Jingles framework is trying to capture. It's also exactly what the NYVRA is trying to capture, albeit with somewhat different elements. But it's the same conception.
Does it matter if strict scrutiny is applied to the New York statute?
I think this court should certainly not be the first court ever to subject any voting rights law or any disparate impact statute to strict scrutiny. It certainly matters in that the strict scrutiny test.
No, his suggestion is it would not survive.
Yeah, we disagree with that suggestion. The 2 parts of the strict scrutiny analysis are, first off, is there a compelling state interest being served?
What would that interest be here?
Yeah, here it's the interest in fighting racial discrimination in voting that takes the form of racial vote dilution in particular. And there is a mountain of evidence in the legislative record that corroborates the problem of racial discrimination in voting and vote dilution in New York. So there's no doubt that this interest is substantiated by an enormous legislative record.
Counsel, if we address the issue of capacity first and have to make that capacity determination, would we even get to the issue of strict scrutiny? Would that come up? And that goes to the issue, how would you analyze this case under the capacity in analyzing the constitutional issue versus a facial constitutional attack?
Thank you, Your Honor. I think it's very important to note that the capacity analysis here is not the same as, does not collapse into the ultimate merits analysis. So here are the differences between the capacity analysis and the ultimate merits analysis. For capacity purposes, the relevant actor is the town, not the state. The relevant action is whatever measure the town might take to comply with the NYVRA. And the relevant legal question is whether the town is right in its extreme theory that any race-conscious action to comply with any anti-discrimination law is necessarily unconstitutional. So that's capacity. On the merits side, the relevant actor is the state, not the town. The relevant act is the NYVRA itself, not any remedial action taken by the town. And the relevant legal questions are, does the NYVRA classify by race? And if so, does it survive strict scrutiny? So they're completely different analyses
So that
for
pretty
capacity and the merits.
That pretty conclusively establishes that capacity and the alleged violation are completely separate. But what is it that the town would, in order to qualify for the exception that they're asking for, it seems as if the town has to at the very least allege it, which they did, but I would think you would argue, and the appellate division seem to think, that something more than just a mere allegation of being forced into unconstitutional action is required in order to overcome the general rule. So what would that be? What's lacking in what the town put forward here?
Yeah, I think this court's own decision in City of New York is clear that a mere assertion that a political subdivision faces the dilemma exception does not suffice. What's required is that the municipality's argument be persuasively argued. That's the language in City of New York. And so to assess the town's capacity argument, this court needs to decide, is the town right or is the town wrong that any race-conscious action to comply with the NYVRA is inherently unconstitutional. And Milligan rejects that argument in the voting context. Ricci rejects that argument in the Title VII employment context. Inclusive Communities does so in the fair housing context.
To get back to Judge Kern's question, because you're Judge Kern's today, right? To get back to Judge Kern's question, does it even require going into an analysis of strict scrutiny or some other level of review, or is that far beyond the panel?
That's far beyond the panel. So to be clear, both the capacity analysis and the ultimate merits analysis do involve the equal protection clause, but they implicate very different equal protection questions, right? One is the classification and strict scrutiny question. The other capacity question is whether the town's theory of any race-conscious remedial action being intrinsically unconstitutional, whether that theory is right or wrong.
So do you know whether, there's two parts to this, do you know whether we have ever had a case in which we have found that a local government satisfied the dilemma exception? And do you know if we've ever found that in a case where the challenge was a facial constitutional challenge?
Your Honor, I believe this court has never found the dilemma exception to be satisfied. So in Jeter and in I guess the World Trade Center later, but in Jeter, most importantly, the court found that the political subdivision defendants there did not qualify for the dilemma exception. In City of New York as well, this court held that New York City didn't qualify for the dilemma exception. In the World Trade Center litigation, this court didn't directly address the dilemma exception, but the Second Circuit did and found it not satisfied.
At least theoretically, it seems to me it would be harder to satisfy in an in a facial case than in an as-applied case.
I think that's right. I think that when the posture of the case is a facial challenge, that then forces the political subdivision to make very grand, sweeping claims as to how any potential application of the statute would necessarily require unconstitutional conduct by the political subdivision. So I don't think that the divide is always one between facial and as-applied challenges. But to the extent a political subdivision is making a facial challenge, it's especially difficult for the subdivision to trigger the dilemma exception, precisely because we don't know what's going to happen down the road, right? We don't know what remedies, if any, might be imposed. And so the only way to find that there is capacity is if the town's sweeping categorical theory is correct.
We'll put it differently. If once there is something that is as applied, so we know what the remedy that's been applied is, it seems to me then it'd be easier to say this is forcing us to do something that's unconstitutional.
Yeah, all of this analysis would be much more concrete, much more tractable if we knew what it was the town was being ordered to do. You know, if the Supreme Court says here is a racially gerrymandered district that we want the town to adopt, then I think the town would have a very strong capacity claim. It would be an as-applied claim, but I think the town almost certainly would have capacity in that event downstream. The point is, right now, we have no idea if the town will be found liable, and we don't know if the remedy will be a new district map or switching to cumulative voting or just having even-year elections, right? There could be any number of
So your
of remedies.
argument is this is premature? They would have to wait until there is a determination and then what is ordered as a remedy if there is a finding of dilution?
Exactly, Your Honor. It's premature to find that the town has capacity at present, but a finding that the town lacks capacity right now doesn't preclude a finding of capacity further downstream in the litigation.
And that's in part because a race-conscious remedy is not necessarily unconstitutional.
Exactly. At this point in the litigation, the only way to find that the town has capacity is if their sweeping theory about any race-conscious action being unconstitutional is correct. And so
And your point is that that is not correct because the law as it stands does permit certain types of race-conscious remedies.
Exactly. And we know this from Milligan. We even know it from the case that the town cites more than a dozen times in its brief, from SFFA. 3 members of the conservative majority in SFFA wrote separately to acknowledge that if universities adopt race-neutral admissions plans, like the Texas 10% plan, that are aimed at racially diversifying the student bodies of the colleges, those sorts of policies are permissible. They don't trigger strict scrutiny.
So give an example of a possible remedy here, given the claims, right, that would not be the kind of race-based remedy that would be unconstitutional.
Well, and to be clear, plaintiffs do not want and are not asking for any race-based remedy here. We're extremely aware of the U.S. Supreme Court's racial gerrymandering jurisprudence. We don't want any doctrine.
Do you think any of the remedies contemplated in the statute are race-based, like potentially redistricting, race-conscious redistricting?
None of the remedies specified in the statute are necessarily race-based. Now, you know, if a district is drawn for a predominantly racial reason, then that would trigger strict scrutiny. But any district for which race is not the predominant motive, any reasonably configured remedial district would not trigger strict scrutiny. So there are vast numbers of remedial districts that would not trigger strict scrutiny. Switching to a different electoral system, like ranked choice voting or cumulative voting, no court has ever found any of those policies to be
That could be a
race-based.
possible remedy in this case, to do ranked voting. That would satisfy the concerns of the plaintiff in this case.
But that's a race-neutral remedy, right?
Absolutely. The only remedies that plaintiffs advocate here are race-neutral remedies, or at most a remedial district that is race-conscious, but for which race is not the predominant motive.
So to go back to that question you were asked just a moment ago about whether there are permissible race-conscious remedies that might be available here, your answer, I would think, would be it doesn't really, it's beside the point because we're not seeking any race-based remedies here. Or is that an incorrect characterization of your argument?
No, it's completely correct that the plaintiffs are not asking for any race-based remedies. With respect to redistricting in particular, there may be race-conscious districts that would be valid remedies, but the line the Supreme Court draws very clearly in Milligan and other cases is between districts that are race-conscious, that's permissible, and districts for which race was the predominant motivation, and that's impermissible. And so, you know, the plaintiffs are disavowing any potential remedies that are districts drawn with a racially predominant purpose.
Counsel, can you discuss how the absence of the first Gingles factor would still comply with the Equal Protection Clause? Can you address that?
Yeah, and again, Your Honor, this would come into play only if we entered the realm of strict scrutiny, which I think we shouldn't be in the first place. So I think it's very clear if one reads Jingles that the court's discussion of the framework in Jingles has nothing to do with the Constitution. You know, the court discusses the Jingles framework for 20-plus pages and never mentions the Constitution. The court's rationale for the first Jingles precondition in particular is only that the court in 1986 was only contemplating single-member districts as remedies. And so if you're only imagining single-member district remedies, the first Jingles precondition makes sense. It basically asks, is there a reasonable, lawful, single-member district that would better represent the plaintiffs and so would cure the vote dilution? But that's a consideration rooted only in potential remedies. It has nothing to do with the US Constitution. If I can just address Bartlett v. Strickland, which is the one case the town goes back to as supposedly constitutionalizing the Jingles framework. Bartlett only involves crossover district claims. It does absolutely not involve any aspect of the rest of the Jingles framework, as the town repeatedly asserts. The NYVRA doesn't even explicitly authorize crossover district claims. And so the relevance of Bartlett here is highly, highly attenuated. And then sorry, I lost my train of thought there. And also see that my time is up. But I did have an additional point with respect to, which is that in Bartlett, the court goes out of its way to praise crossover districts. And so even if the NYVRA does authorize crossover district claims, Bartlett says these districts are models of the kind of interracial cooperation the Voting Rights Act is trying to achieve. And Bartlett says that states are free at their discretion to draw, to require the creation of crossover districts. And so it's very clear that Bartlett is not constitutionalizing anything, not even with respect to crossover district claims. And I see my time has expired, and so I'll sit if the court has no further questions.
Thank you.
May it please the court, Judith Vail for the state. I'd like to make 3 or 4 points on capacity, hopefully additive rather than repetitive, and then turn to the merits if the court were to reach the merits. On capacity, it is important to keep the capacity separate from the merits because that is the point of having a capacity bar. The whole point of the lack of capacity, the bar, is that a municipality is not allowed, generally speaking, to get a merits ruling that would invalidate a state statute unless they can fit into an exception. Under Newburgh's theory here, anytime that a municipality simply invoked, just uttered the words, it's unconstitutional, that they could then fit within the exception and get a merit, and ultimately get a merits ruling if the two overlap. So that would put the cart before the horse, and the court should be very careful to keep those two things separate. I certainly agree with my colleague's description of how those things are separate substantively, and it is important to keep them separate also because it goes to it is not just a technicality. It is a threshold issue that goes to the relationship between the state and its subdivisions. This is why it does not matter that Newburgh is raising the facial challenge as a defendant rather than being in the plaintiff.
So the appellate division was incorrect when it said that we should consider the merits when determining whether or not there's capacity?
I don't think the appellate division quite said that. There is certainly some overlap between what one needs to look at to resolve the lack of capacity and what one would look at the merits, but they are not exactly the same. And is it important to ultimately keep that distinction?
We have to know the nature of their argument.
Yes, and I do agree with the plaintiff's counsel that one of the reasons why there's a substantive separation is because the exception that Newburgh is invoking focuses on the actual compliance that Newburgh would have to do. It is not just liability in the ether, because liability in the ether doesn't require a municipality to do anything. You need to focus on, in every application, every possible remedy, would Newburgh be required to violate the Equal Protection Clause, and that's a no.
So you agree, should this action go forward, that they could, however, raise this claim if indeed there was some remedy ordered or remedy that was being considered, that they would assert forces them to take unconstitutional actions?
Yes, we agree that there could be an as-applied situation down the road where it becomes clearer that if that remedy is actually instituted by Newburgh, they have a colorable argument that that might actually require them to violate Equal Protection Clause. But we are so far away from that here, in large part because they are raising this sweeping facial challenge, and because of that, they don't have capacity now, but they might later.
And plaintiffs may not make out their claims.
That is also a possibility, Your Honor, as well. And I think I'd like to just touch on the Supremacy Clause argument that was made. Two responses to that. First of all, to the extent they're saying that it has to be that someday, somehow, they could bring a federal constitutional claim, I think that's where the as-applied challenge comes in. We're not saying that there could never, ever be a situation where Newburgh could ever raise a challenge. In an as-applied situation, they might have capacity. And second of all, my second point is the Supremacy Clause does not give a particular litigant a right to bring a claim. It is not about who can bring the claim. It is about if you have a proper litigant and you're actually looking at the merits, and there's a conflict, then federal law would control. And the Jeter case is one in which the municipality was trying to raise federal constitutional claims and did not have capacity to do so. And in this respect, lack of capacity is not different from other threshold bars like standing, or there are other types of lack of capacity as well. In all of those instances, the particular litigant is not the proper one to raise the claim. The Supremacy Clause doesn't say anything about that.
An individual voter in Newburgh wouldn't have a capacity bar, presumably.
Correct. Of course, Your Honor. That is correct.
So the town is not the constitutionally necessary defender of the Supremacy Clause.
And I will note, going back to the sort of exception swallowing the rule problem that I see in Newburgh's arguments, by invoking the Supremacy Clause, if you follow that logic, that would mean that a municipality could always have capacity to bring any federal constitutional or federal statutory claim. It could just skip over the capacity bar and entirely swallow the rule. And this court was very clear in the city of New York, and the Second Circuit said it again in the World Trade Center litigation, that the exceptions to the capacity rule exceptions to the bar should not swallow the rule. If I could turn to the merits, if the court were to get to it, I think the fundamental error in Newburgh's argument is this idea that providing a remedy for racial discrimination when racial discrimination has been proven is itself a racial classification that is subject to strict scrutiny. That is simply wrong. It is not correct. If it were correct, it would take down nearly every anti-discrimination statute, certainly the ones that allow for disparate impact, but even ones that allow for disparate treatment claims, because nearly every anti-discrimination statute provides a remedy to the victim of discrimination if they prove their claim. And they give some benefit in the form of legal relief to the victim. If they didn't, there wouldn't be redress. But that is not itself a racial classification. What is important to look at is the remedy itself race neutral or not? And here there are many, many types of remedies under the statute that are facially race neutral. As the Plaintiffs' Counsel described, alternative election systems don't require any districting at all. They are entirely race neutral. They treat every voter the same. And even instituting a district system on its face is race neutral. There are many, many jurisdictions all across this country in New York that use district systems. That in and of itself does not involve race at all, let alone race predominating.
Thank you.
Thank you, Your Honor. Just three brief points in view of the likely next step in this case, which would be to the U.S. Supreme Court. Point one, when this challenge to the NYVRA goes to the U.S. Supreme Court, I think it would be quite unfortunate if, as part of that, the argument would be made that the courts of New York are not open to facial challenges under the U.S. Constitution. I gave an extreme hypothetical earlier that shows the absurd results of that kind of reading of the capacity clause, and I think that it would be much better, Your Honors, if the court doesn't agree with our facial arguments on the merits, that they be disposed of the merits, so we don't have to have the supremacy clause complication. Two, on the merits, it's just, you hear these arguments and you feel like you're living in a parallel universe. If you look at the briefing in the Louisiana case that will be argued tomorrow, none of these arguments are being made because my friends know, well, they made a couple of amicus briefs, but none of the parties are making them that are defending Section 2, because parties know the U.S. Supreme Court's not taking these arguments seriously. What the arguments are on the Louisiana case is that the venerable Section 2 is so carefully tailored with the three Gingell preconditions and the second step that it satisfies strict scrutiny. All of the arguments that you heard around the merits are not the ones that the advocates are currently trying to convince the U.S. Supreme Court are really taking seriously, given the modern jurisprudential reality. Point number three, the appellate division gave us a stay pending this disposition. As I signaled, the next step, if the case goes the way it appears to be from the signals from the bench, would be to go to U.S. Supreme Court. We would respectfully ask to continue the stay that the appellate division put on, and we would promptly file any adverse decision. We'd promptly file a cert petition to the U.S. Supreme Court. The U.S. Supreme Court, candidly, would very likely hold that cert petition in view of the Louisiana case, raising so many of the same issues. The U.S. Supreme Court would then decide that case. It would provide very important guidance to see if I'm right, if they're right. If they're reading Allen correctly, if they're reading the current Supreme Court correctly, including the landmark SSFA case, the U.S. Supreme Court likely will GVR any decision, and then this court can have that knowledge. I think it would be quite unfortunate if my clients, which is a small town of 32,000 people, have to go through a full, very expensive trial. Meanwhile, the U.S. Supreme Court is in the process of deciding a lot of the issues that we're disputing here, including if Louisiana wins in that case and Section 2 is invalidated or in part or in whole, I think there would be no serious argument that the NYVRA would survive. And in light of that reality of where we are in the jurisprudential world, I would urge the court not to put this small town through a very expensive trial before the U.S. Supreme Court can give us guidance as to what it thinks about these issues.
Thank you.